Yes. Good morning, good evening, everybody. I, Dr. Meenakshi Kalra, welcome you all on behalf of the Supreme Court Advocate on Record Association to this lecture series. Today, we've all gathered here for one of the important topics of directions in pending legislation, medical negligence, and environment in the leading cases exam for the upcoming AOR examination. We have the honor to have with us today Senior Advocate Shailesh Madiyal, sir. We welcome you, sir, and we are thankful to you for taking out time. We're showcasing this lecture live on YouTube, and if anybody has any questions, the same may be put in the chat box, and the same will be taken up by Sir at the end of this lecture. I'll just start with introducing Sir. Sir has finished his law from University Law College, Bangalore in 2002 and practiced law in Bangalore from 2002 to 2005 in the chambers of Mr. Ashok B. Hinchkiri, who later became a judge of the Honorable High Court of Karnataka. After shifting to Delhi, he practiced across various courts and tribunals. He qualified the AOR exam in 2011 and was appointed as an additional Advocate General for Jammu and Kashmir in the year 2023. He was designated as a senior advocate of the Supreme Court of India on 19 January 2024. As an AOR and then as a senior advocate, he has appeared in several important cases representing private as well as government bodies. He has appeared in cases across various subject matters, including matters pertaining to constitutional law, criminal law, service law, and commercial law. I request you, sir, to please start with your session now.
Thank you, Meenakshi. So, just to give a gist, I have been given 6 judgments to deal with spread across 3 topics. The first topic is directions pending legislation. The 4 judgments there are Vishaka, Ramchandra Rao, Common Cause, Ashwini Kumar, and Ashwini Kumar. So I'll deal with that first. And when we say directions pending legislation, essentially, this has a bearing on the doctrine of separation of powers. The separation of powers between the executive, the legislature, and the judiciary. So before I deal with each one of these judgments, I just want to give 3 or 4 features of the doctrine of separation of powers as it exists in India. The first feature, and very interestingly, is that the Constitution itself does not specifically say anything about separation of powers between the executive, the judiciary, and the legislature. The indicator that, in fact, there is a separation of powers comes from the fact that all of them, or each one of these aspects or branches, is dealt with in different parts of the Constitution. For example, the executive wing of the Union is dealt with in Part 5, Chapter 1. The judiciary is dealt with in Part 5, Chapter 4 and Part 6 of Chapter 5. The legislature is dealt with in Part 5, Chapter 2. The Union legislature is in Part 5, Chapter 2, and the state legislature is in Part 6 of Chapter 3. So the first feature is that the Constitution itself does not specifically make or mention separation of powers. Having said that, there are multiple articles within the Constitution which give an indication that in addition to being finding place in different chapters or different parts of the Constitution, there is in fact a separation of powers. And these indicators, just to give a couple of illustrations, you would find these indicators in Article 50 and Article 122, subclause 2. Article 50 says that the state shall take steps to keep the judiciary separate from the executive insofar as public functions are concerned. That's one. Article 122, subclause 2 deals with the validity of proceedings in Parliament and says that the validity of proceedings in Parliament are not to be called into question in a court. Of course, I mean, even this has now been diluted. I'll come back to that later. But these are all articles which give an indication that it was the intention to keep the three branches separate and the powers exercisable by the three branches separate. The next feature, which is an important part of the separation of powers, is that in the Indian system, and now this is recognized by judgments, in the Indian system, the separation of powers is not an absolute separation of powers, which means that the three branches would not act in silos and completely isolated of each other. And yet, at the same time, the division of powers between these three institutions must be respected. You could just note in this regard, Bhim Singh versus Union of India, which is the citation is 2010 5 SCC 538, which says something to the effect that I'm not quoting the exact words, but which says that while overlapping of functions is inevitable and is not strictly prohibited, emphasis on this part that it is not strictly prohibited. What is prohibited is the exercise of functions of another branch in a manner that it takes away the regime of constitutional accountability. Now, so this really gives an indication that the three branches don't act in silos. At the same time, gives a somewhat gray concept that it must not infringe upon another branch in a manner so as to take away constitutional accountability. Now, much before Bhim Singh, there is one other judgment on this very aspect that I want to refer to. I'll not deal with it in detail because it's not one of the cases that I don't even think it's there in the leading cases, if I'm not mistaken. The second judgment is Indira Gandhi versus Raj Narayan, 1975 supplementary SCC 1. This is a constitution bench judgment. And this says something very interesting. It says that while a rigid separation of powers under the which finds place in the American or the Australian constitution does not apply in India, within each constituent authority, there is no demarcation of powers, and the constituent powers itself are not bound by the separation of powers. This is very interesting. The reason is this. Perhaps what this means is that within the legislative branch, there may be certain executive or judicial functions that the legislative branch within itself functions. For example, if there is a breach of privilege motion. So within the legislative branch, there is no demarcation or separation of powers. But inter, say, one branch and another, there is a demarcation of powers. This is just by way of interest. I'm mentioning this because I found this to be a very interesting concept in one para of Raj Narayan. That is para 47 to 48 of Raj Narayan. This was the second feature that I wanted to mention. The third feature that I want to mention is that while overlapping of functions between the executive and the legislature is somewhat normal because, as everyone knows, a part of the executive is also necessarily a part of the legislature. So while overlapping of functions and powers between the executive and the legislature is much higher, the division of powers between the judiciary and the other two branches of the state assumes far more importance, since it is the judiciary which is often a balance and check to the actions of the legislature as also the actions of the executive by way of judicial review or interpretation. That is point number 3. Point number 4 is, notwithstanding that there is a thin line separating the powers of between the powers of the judiciary, legislature, and the executive. As I mentioned earlier, there is some amount of overlapping. There is a gray area as to what actually is permissible and what is not. But at least 3 judgments, that is Keshwananda Bharati, IR Coilo, that is 2007, 2 SCC 1, and the NJSC judgment, that is SCAORA versus Union of India. At least 3 of these judgments recognize the doctrine of separation of powers as a basic structure of the Constitution. So the gist of what I said so far, what I mentioned as features of the basic structure as it is used in features of separation of powers as it is used in India is the Constitution does not specifically mention it. It is not a straitjacket. The 3 branches do not work in silos, and yet it is one of the basic structures of the Constitution of India. Now, the reason I mentioned this and I got a little deeper into this before I deal with each of these 4 judgments dealing with directions pending legislation is that I would encourage everyone, even when they are writing about a particular judgment, to analyze that judgment in the light of these 3 or 4 aspects, which I mentioned just now. So let me straight away dive into the first judgment, which I'll be dealing with. And that is Vishaka versus State of Rajasthan, 1997, 6 SCC 241. And this is a judgment of 3 honorable judges, Justice J.S. Verma, Justice Sujata Manohar, and Justice Kirpal. Just very briefly, the background to this case was a gang rape incident which had taken place, criminal proceedings which had started, but independent of the criminal proceedings, a PIL was filed by an NGO, Vishaka, under Article 32 of the Constitution for the enforcement of fundamental rights of working women under Articles 14, 19, and 21 of the Constitution, in the light of violation of the principles of gender justice and for prevention of sexual harassment of working women by filling in the vacuum in the existing legislation. So what was the position when this case was instituted and this judgment came to being? There was no specific law dealing with the prevention of sexual harassment of working women. So therefore, the question was, in the absence of such a law, would the court perform what many would think as a legislative function, which is to issue guidelines which in effect form the law for the purposes of protecting the rights of working women in the workspace. The court did finally issue guidelines. Those guidelines were interim guidelines till the parliament framed a law. And the reasoning / ratio of this judgment was 2 or 3 things, which I'll just enumerate. One is that it recognized that the primary function of ensuring dignity and safety of women at the workplace and for devising a mechanism for its enforcement is that of the legislature. That the court emphasized. But the court said that when there is a situation that a working woman is faced with violations of Article 14, 19(1)(g), and 21 on account of the likelihood or the existence of sexual harassment at the workplace, then it would be permissible for the court to fill in, and I emphasize this, to fill in a vacuum which exists because there is an absence of legislation in this regard. So therefore, there was a twin test. One, there is a violation of fundamental rights. And second, there is a vacuum of legislation for the purposes of protection of these fundamental rights. And when both these occur at the same time, the court could frame guidelines to protect the fundamental rights of working women. This is in essence, the ratio of the judgment. But as far as the reasoning goes, just very briefly, the ratio you will find at para 3 of the judgment. I am not going to read it out, but it's at para 3 of the judgment. As far as the reasoning is concerned, the court also said, referred to Article 42 of the Directive Principles of State Policy. It referred to Article 15 of the Constitution. It referred to the Human Rights Act 1993. And it also referred, importantly, to the Convention on Elimination of All Forms of Discrimination Against Women, and then said that the court under Article 253, because the legislature under Article 253 has the duty to make laws to give effect to international treaties, and there is an absence of such law, the court then went ahead and framed certain guidelines. Those guidelines, again, I will not repeat. They are part of the judgment. Today, they may be academic because now it is, of course, replaced by the Act, which that is the Sexual Harassment at Workplace Act 2013. The judgment, however, is important for the purpose that of answering the question as to under what circumstances the court can go ahead and frame guidelines, and whether that would not be impinging on legislative functions, which someone could argue is outside the purview of the judiciary. Just as a matter of interest, even in 2014 5 SCC 438, that is National Legal Services Authority versus Union of India, with regard to transgender rights and rights of a third gender, there also the ratio with regard to international conventions and Article 253, which was used by the court in Vishaka, the very same reasoning has been used even in that case. So it may be useful to make a reference to 2014 5 SCC 438, which I am told is part of the leading cases when you are referring to this judgment. The second judgment, which you can, as an add-on to Vishaka, you can refer to as Nilbati Behera, State of Orissa, AIR 1993, SC 1960, where the court relied on the covenant on civil and political rights. So these are the two add-on judgments to Vishaka. If you are dealing with Vishaka, it may be useful to refer to this. But otherwise, the ratio is that in order to protect fundamental rights in the existence of a vacuum because of the absence of legislation, the court may issue guidelines. Now, one other aspect on Vishaka, when I'm dealing with Vishaka, which I just want to mention is that in Common Cause versus Union of India, 2018 5 SCC 1, the Supreme Court has issued directions relating to advance directives with regard to, since there was no clear law on euthanasia or advanced medical directives in statutory law, just as in Vishaka, even in Common Cause 2018, the 2018 Common Cause, there are multiple Common Cause judgments. The 2018 Common Cause judgment, there also guidelines were laid down because there was no, on the basis that there was no specific legislation and there was a vacuum on account of the absence of legislation. This is as far as Vishaka. I'll come to the next judgment, which is a judgment of 7 honorable judges, of which 6 have concurred with each other. Justice Dorera Swami Raju partly concurred, but partly had a dissenting view. Now, this is a very important judgment. Of course, this is Ramchandra Rao versus State of Karnataka, 2002 4 SCC 578. The facts leading to this case are important because I think I did find that 1 or 2 questions in some of the papers in the last few years referred to certain lines used in the judgment and asked for an analysis of this judgment. So, this judgment is a seven-judge judgment, as I said, and the question that was referred for opinion was as to whether, in the light of AR Antule's case, and in the light of the observation in AR Antule's case, that it is neither advisable nor feasible to draw or prescribe an outer limit for conclusion of all criminal proceedings, whether the law laid down by certain subsequent judgments, which I will mention, certain subsequent judgments, whether the law laid down that as soon as there is a delay in the trial, the proceedings would get quashed. Would that be good law or not? To put it in other words, AR Antule had come to the conclusion that it is not for the court to fix an outer limit for the conclusion of a criminal trial, even if it may be advisable to have an outer limit for the conclusion of a criminal trial. Now, AR Antule was a judgment by 5 judges, and it referred to the right to a speedy trial under Article 21. In spite of a 5-judge bench in AR Antule saying that we would not frame such a guideline, at least 4 subsequent judgments ended up actually doing exactly that, that is, acquitting people or discharging people or quashing proceedings purely on the basis that the trial had taken too long or had not concluded within a reasonable time. Of these, I could find at least one, which is Rajdev Sharma versus State of Bihar, which appears to have relied on a particular para of AR Antule, and I would submit wrongly, to come to the conclusion that if the trial has taken too long, it should be quashed. The 4 judgments which finally led to the reference to the larger bench, I can just mention, is one is the parent judgment, which is AR Antule. Second is Common Cause 1 versus Union of India, 1996, 4 SCC 33. Second, one second. Let me just give you the citation of the second case as well. Second, Common Cause 2, which is I'll give you that citation. The third judgment you can note down in the meanwhile. Rajdev Sharma 1 versus State of Bihar, 1998, 7 SCC 507. The third judgment is the third judgment is Rajdev Sharma 2 versus State of Bihar, 1999, 7 SCC 604. And Common Cause 2 versus Union of India, 1996, 6 SCC 775. So, the background, the gist of the background is, Antule took the view that we will not frame any guidelines for speedy trial, or in the sense say that as soon as the trial has taken unreasonable amount of time, the proceedings would be quashed. But the subsequent 4 judgments, in some manner or the other, sometimes relying on Antule, decided to quash or discharge the accused purely on the basis, or issue guidelines purely on the basis that once the trial has taken too long, the person is entitled to be discharged. Therefore, this question finally came up to 5 judges and then to 7 judges. The majority opinion was that AR Antule was right, and the court cannot get into the field of framing guidelines, especially when there were certain other provisions within criminal law which provided a remedy in case the trial had taken too long. It could be 482, it could be any other provision. But since there were other remedies merely because it is advisable to speeden up trials, the court would not get into the business of framing guidelines. The second reason, of course, why the court disagreed with the four earlier judgments, was that in terms of the doctrine of precedence, A.R. Antony ought to have been followed. The ratio in Ramchandra Rao is very important. And I am just reading out a line. This specific line forms part of one of the questions in one of the earlier years, which is that the powers of the Supreme Court under Articles 32, 21, 141, and 142, even if read in the most liberal manner, does not allow the court to do each and everything, including creation of legislation. Now, this is part of para 27 of the judgment. And while courts are permitted to pass directions on facts and circumstances of each case, they cannot, like a legislature, lay down provisions applicable to all cases. What does this mean? In a particular case, if the trial has taken too long, the court may decide to quash the proceedings or to discharge the accused. But it could not, as a general rule, lay down overarching guidelines which would allow either discharge or benefit to an individual in all similar cases. That would be within the purview of the legislature. This being the ratio of the case, I would encourage you to take a look at a recent judgment. This is like I said, the judgment which I just dealt with, Ramchandra Rao, is a judgment of 7 judges. Now, a recent judgment, which is State of Tamil Nadu versus Governor of Tamil Nadu, that is 2025 INSC 481. You must have already gone through this judgment. I think in some of the earlier lectures also this has been dealt with. This was a case where the governor's power under Article 200 of the Constitution was the subject matter. That is, once the state legislature passes a bill, sends it to the governor, then under Article 200, which uses the words as soon as possible, it says that the governor should deal with it as soon as possible. The question then was, would as soon as possible, can the court interpret this to mean a specific time frame? A two-judge bench of the Honorable Supreme Court has finally, in its conclusions, said, it has several conclusions, but I'll only deal with what is relevant for this topic. At paras 237 to 239, has said that the words as soon as possible must be given an interpretation keeping in view the purpose of the article, and therefore a time frame of 1 month and 3 months respectively, 1 month in respect of the governor, 3 months in respect of certain other functions of the governor. It's not important as to what the function was, but imported a timeline of 1 month and 3 months to the functioning of the governor. Therefore, in effect, a period of limitation was added when in Article 200, when the article itself did not prescribe such a limitation. The court said that this does not go contrary to the Constitution, because the Constitution already uses the words as soon as possible. Therefore, it is in keeping with the objective of the provision. It may be worth your while, if faced with a question which deals with Ramchandra Rao, Vishaka, etc., to analyze or to critique the judgment in Governor of Tamil Nadu, keeping in view, when I say critique, I mean analyze, the judgment in Governor of Tamil Nadu, keeping in view the law laid down in Ramchandra Rao, Vishaka, and Ashwini Kumar, which I'll deal with subsequently. Because in Ramchandra Rao, what was specifically said is that a period of limitation cannot be brought in by the court when the legislature has not brought in any such period of limitation. On the other hand, in Governor of Tamil Nadu, a specific period is brought in for the functioning of the governor and, in fact, the functioning of the president. Since I have referred to this judgment, I should also point out that there is, I understand now, a presidential reference under Article 143, at least from news items I could see, which has been sent to the Supreme Court. And some of the questions in this reference have a direct bearing on the subject that we are dealing with today. So some of the questions are as to whether, in the absence of a constitutionally prescribed time limit, can timelines be imposed through judicial orders for the exercise of powers under Article 200 by the governor? Now, please juxtapose this with Ramchandra Rao. You will see a direct connection between this question and what was dealt with in Ramchandra Rao. Another question that appears to have been referred under Article 143 in a presidential reference is, are the decisions of the governor and the president under Article 200 and 201 justiciable at a stage before the law comes into force? And is it permissible for the courts to undertake judicial adjudication over the contents of a bill before it becomes law? Which in effect means that would judicial review of a bill, which is essentially an act of the legislature, be permissible when it has not yet become an act? There are several other questions which are referred. This is available, I find, in on the Supreme Court website also, so you can just check it up. But it would, I think, add value to any answer with regard to separation of powers if this judgment and this presidential reference, that is Governor of Tamil Nadu and the presidential references, referred to. I'll now come to the third judgment. I have finished Vishaka and I have finished Ramchandra Rao. With Ramchandra Rao, the add-on judgment which you can deal with is State of Tamil Nadu versus Governor of Tamil Nadu. The third judgment which I have been asked to deal with is Common Cause versus Union of India, 2008, 5 SCC 511. This is a judgment of two honorable judges. Since I may be running out of time, I'll not spend too much time on this. This is a short judgment you can go through. This refers, the question over here was as to arose out of a PIL seeking directions with regard to be issued by the court with regard to road safety, etc. The judges who were part of the bench in this case were Justice Markanday Kadju and Justice Sema. They differ on, there is a dissenting view of Justice Sema on certain aspects, but on the specific aspect with regard to whether the court should frame these directions or not, both are concurring. The court held that it is only, in fact, it reiterated what Vishaka and Ramchandra Rao had said. And the ratio of the judgment is that it is only when there is a complete vacuum that the court may pass directions to fill up that vacuum. So this, if you recollect, this is the exact, these are the exact words used in Vishaka also. And the Justice Kadju's judgment uses the word judicial excessivism and says that judicial excessivism must be avoided and making of a new law is not a legitimate judicial function. The reason why this is an important case, although a short judgment, is that it reiterates what we had discussed earlier, that a mere shortfall in the law cannot allow the court to form guidelines constituting a new law. And it is only in cases of obvious vacuum. This phrase obvious vacuum is used repeatedly in judgments. Therefore, I am also stressing on it. You may want to like to use it. It is only in cases of obvious vacuum that the court can step in to frame guidelines for the enforcement of fundamental rights. The fourth judgment, which is the last judgment with regard to this particular topic, that is directions pending legislation, is Dr. Ashwini Kumar versus Union of India, 2020, 13 SCC 585. This is a judgment I would suggest everyone goes through in detail, because it being recent in origin, deals with most of the earlier judgments, and in fact quotes extensively from most of the earlier judgments. So once you read this, it will give you a broad idea as to how all the previous judgments have proceeded and how the law on this particular topic has evolved. The case before the Supreme Court related to a prayer for directions by the Supreme Court to the Parliament to enact a standalone and separate legislation on custodial torture in furtherance of the Torture Convention, which India had signed but had not ratified. So you will find that here also what was sought was a direction by the Supreme Court, and a direction which in effect would have either framed law or directed the legislature to frame a law, which now, of course, is not permissible. And in this judgment, if you take a look at para 9, all the way up till para 14, there is a beautiful analysis of the doctrine of separation of powers as is applicable to India. I'll not repeat it. I had essentially repeated it in my introduction, but you may go through it because it's well written and would add value to your answer if there is a question on this topic. The court has referred copiously to another judgment, Kalpana Mehta versus Union of India, 2018, 7 SCC 1. And by relying on this judgment, on Kalpana Mehta, the following propositions fall from this judgment, that is from Ashwini Kumar. The first proposition of importance is that the legislature is supreme in the field of legislation and lawmaking, and yet this power of the legislature is distinct and not at par with the supremacy of the Constitution. On the other hand, the power of the court normally is only twofold. First, interpretation of a law, and second, judicial review of a law. This is the first proposition. Second, the power of judicial review is necessarily to be examined along with the concept of judicial restraint. Please mark these two phrases, judicial review and judicial restraint. While in the realm of judicial review, the court enjoys very, very wide powers, while exercising interpretative power, the court would draw strength from the spirit and propelling elements underlying the Constitution, but must be alive to the concept of judicial restraint. Therefore, it is almost as if there is a caution to courts that whether interpreting or whether exercising the power of judicial review, there must be an element of judicial restraint. This particular aspect you will find at para 28 of this judgment. Point number C, para 29. Now, first the court says that the two essential functions of the court is interpretation of a law and judicial review of a law. But then at para 29 comes in the third facet, which is that there are a few occasions when the court appears to have legislated beyond what can be strictly construed as either interpretation or judicial review. What are these two situations? These two situations are the very two situations which we have described in Vishaka and Ramchandra Rao thereafter. That is, one, the Constitutional Court on the path of interpreting fundamental rights has acted to guard life of individuals when there has been a substantive and gross violation of rights. So therefore, A, there has to be a substantive and gross violation of rights, and I would argue of constitutional or fundamental rights. That's one. And second, there is a vacuum or absence of laws or guidelines which effectively protect those fundamental rights which are violated. So therefore, this third aspect of the jurisdiction of the judiciary is added. One, interpretation; second, judicial review; and third, framing guidelines when these two tests are met. This was the third proposition which falls from this particular judgment, that is, which falls from Ashwini Kumar. The fourth proposition is that the court does not just stop at giving these tests which I just stated. The court goes on to illustrate and says that such situations would generally arise when there is either a gross violation of human rights or a gross environmental degradation and pollution, which requires the court to act beyond the purview of purely interpretative or review functions. So these are illustrations given. And if you look at all the judgments where the court has actually gone in and done something which is in the nature of issuing guidelines or going a little beyond purely interpretation or judicial review, then they would invariably be matters pertaining to the environment or human rights. The fourth proposition which I want to refer to as arising in this judgment is that this, you can refer to this at para 30 of the judgment, which is that any intervention by the judiciary, even to give a suggestion to the parliament or the state legislature to frame a law, could be interpreted as judicial participation in the enactment of law. Therefore, the court certainly cannot, even if it does in some situations frame guidelines, it certainly cannot direct the parliament to frame a law. So these 4 or 5 aspects which I mentioned are the essential parts of this judgment. And when you do read this judgment, you will get understand the connection between this judgment, Ramchandra Rao, and Vishaka, because this is very, very exhaustive, deals with a large number of case law and quotes a large number of case law. These are the 4 judgments with regard to the first topic, that is directions pending legislation, which the topic I will expand a little more to say it is directions pending legislation and separation of powers. Because several questions are with regard to separation of powers, and it will be these judgments are what will answer those questions. The next Two judgments are one judgment on medical negligence, which is Balram Prasad versus Kunal Saha, and the last on environment, which is Vellore Citizens Welfare Forum. I'll deal with them quickly. Now, insofar as medical negligence is concerned, Kunal Saha, that is 2019. One second, let me just get the citation. Yeah, 2014, 1 SCC 384 dealt with the manner in which compensation is to be granted in cases of medical negligence. I need not take you through the facts of the case. You can go through the facts in the judgment itself. But a key element of this case was that the quantum of compensation in a case of medical negligence, the quantum of compensation that was claimed was 97 crores. What was granted by the NCDRC was 1.5 crores. The question, therefore, the first question that was answered, therefore, was as to whether compensation can be granted in excess of what is claimed. And the court said it can be. The ratio with regard to this particular aspect is to be found in para 113 and around para 113, a few paras thereafter. The court says that, sorry, you can start from 110, para 110 in fact. The court says that the objective finally in determining compensation is restitution. That is to put the person back at the same level as he would have been. And therefore, the court draws a distinction between two concepts. One is future loss of income. That is one phrase. And the second is further prospects of income. Future prospects of income. So, by applying future prospects of income, the court said that the deceased in that particular, in Kunal Saha's case, the deceased was a graduate student when she died. But she was a graduate student from one of the top universities in the US. And expert evidence was led to show that after she had passed out, she was likely to earn a certain amount of income, which is likely to have grown in the future. And that, therefore, would constitute future prospects. And therefore, future prospects would be far wider than merely future loss of income, which basically would be income determined on the date of death. The court also said that it is the duty of the commission to award, and I use this phrase in single inverted commas, just and reasonable compensation. And because it is the duty to award just and reasonable compensation, the commission in some cases is not limited by the compensation claimed. If the commission, for good and telling reasons, feels that the just and reasonable compensation would be more than the compensation actually claimed in the complaint, then it is not beyond the powers of the commission to award such compensation. Two other aspects which I'll just refer to in this judgment because of the time constraints is para 118 to 125 of this judgment says, because one of the issues was as to while determining compensation, can the multiplier as used under the Motor Vehicles Act be used? The court said you can't use multiplier as a straitjacket formula. The reason given for not using multiplier, the concept of a multiplier, which is there in the Motor Vehicles Act, was it said that normally the use of the multiplier is in a no-fault claim. Whereas under the Consumer Protection Act, it is not a no-fault claim. You are actually establishing negligence of the doctor and then coming to the conclusion that compensation was due and payable. The last aspect on this particular judgment that I just want to touch upon is the vicarious liability of a hospital for the negligence of the doctors. The court said that a hospital is vicariously liable for the negligence of the doctors. And finally, while granting compensation, it divided the compensation amongst the doctors, but a majority of the compensation was apportioned to the hospital. And in doing so, it has relied upon an earlier judgment, which is Savita Garg versus National Heart Institute, that is 2004 8 SCC 56. The reason I keep referring to earlier judgments is that it adds value when you are analyzing a case. So otherwise it's an open book exam. So this particular judgment you will more or less have in front of you, but it will add value if you refer to an earlier judgment which has either been not followed or or referred to or not accepted, etc. This brings me to the last judgment, which I will be dealing with, which is Vellore Citizens Welfare Forum versus Union of India, 1996, 5 SCC 647, and this is under the heading Environment. So I dealt with 4 judgments with regard to judicial separation of powers, 1 judgment with regard to medical negligence, and the last judgment with regard to environment and compensation for environmental damage. This again is a very interesting judgment because, or let me just give a background. This judgment arose on account of environmental pollution caused by tanneries in the state of Tamil Nadu. And the court said something very interesting, although there are references to these concepts in earlier judgments, but there is a lot of clarity in this judgment. And at para 10, the court says that the traditional concept that development and ecology don't go hand in hand or are opposed to each other is outdated. So very often, these 2 aspects, development and ecology, become a clashing point. And we'll very often look at one versus the other. But the court said that as it is an outdated concept to say that development and ecology are contrary to each other. And the new concept was that of sustainable development. It was not actually really new because it is referred to earlier. It is also referred to in the Stockholm Declaration, if I'm not mistaken, para 10. It refers to the Stockholm Declaration. But what is more important is, as facets of sustainable development, several new principles were propounded. And 2 of these principles are very important and are often used in environmental cases. The first is the precautionary principle. What is the precautionary principle? Can you just give me the page? What is the precautionary principle? The precautionary principle is that, so the precautionary principle is that it is the duty of the statutory authorities to anticipate and prevent anything that is likely to cause environmental degradation or damage. It also means that, and this is very important, the onus to prove that an action is environmentally benign is on the person who does that action. Therefore, if there is for example, a thermal power plant, it is not for somebody else to prove that the thermal power plant has actually caused certain amount of damage. If in the normal course, a thermal power plant would be environmentally degrading, and if the thermal power plant then claims that it has acted in a manner that does not degrade the environment, it is for the plant to prove it and not the other way around. This is the precautionary principle. The second principle that is relied on in this judgment as a facet of sustainable development is the polluter pays principle. The polluter pays principle was earlier referred to in Indian Council for Enviro Legal Action and Others, that is 1996, 3 SCC 212. And it is somewhat similar to the strict liability rule in Rylands versus Fletcher, which all of us studied in college and never thereafter. What it means is that when you are doing an act which is dangerous, irrespective of whether you have been negligent or otherwise, if there is a damage to the environment, then the polluter must pay for it. So it cannot be a defense of a polluter that he had not acted in a negligent manner and therefore was not liable to compensate for the pollution that is caused. If he has caused the pollution, irrespective of negligence, he definitely is required to pay for it. How did the court justify bringing these principles into the law of the land in spite of no specific mention of these principles in any of the statutes? It did so by saying that both these principles were part of various international conventions and customary international law. It then said that when it is part of customary international law, there are several statutes in the municipal sphere that is within the country. For example, the Environment Protection Act and the Water Act, Air Act, etc., which indicate, although don't specifically say it, which indicate a reference to similar principles. And therefore, the court then said that the precautionary principle and the polluter pays principle are part of the environmental laws of our country, that is India as well. In doing so, at para 15, the court has referred to two judgments. I'll not go through those two judgments. I'll just give the citations. That is ADM versus Shivkant Shukla, 1976, 2 SCC, and Jolly George Verghese versus Bank of Cochin, 1982, SCC 360. These judgments are referred to reiterate the proposition that customary international law, if it is not contrary to the municipal law, shall be deemed to have been incorporated in the domestic law and shall be followed by the courts of law. This completes my analysis of these judgments. Before ending, I just want to share one view. While writing the paper, I had said this in between. If a particular judgment is being referred to or asked, it may be a better idea to also put in a small para critiquing or analyzing that judgment instead of simply saying what that judgment says. That analysis could be referring to earlier judgments or in whatever manner, because that will demonstrate original thinking on the part of the person writing the paper. Thank you so much. Thank you, Meenakshi.
Thank you. Thank you so much, sir, for such a detailed lecture. I would now take a few questions that have been asked in the chat box.
Yeah.
The first question is by Prakash Jadhav, and he's asked that whether in any connection in case of Vishaka versus State, Air India versus Nargish Mirza, and Sheila versus State of Maharashtra before protecting women on workplace.
Can you just repeat the question again?
Yes, I will.
Yeah.
So basically, he's asked that was there any connection in the case of Vishaka versus State, Air India versus Nargish Mirza, and Sheila Bare versus State of Maharashtra for protecting women on workplace?
So, if I'm not mistaken, Air India Nargesh Mirza dealt with the rights of, I think cabin crew, correct? The employment terms with regard to family cabin crew.
Right.
Now, the connection is that those judgments also, and Sheila Barse with regard to prisoners, female prisoners. Now, the connection is that those judgments also, I mean, the details of those judgments I can't, without looking at it, talk about. But the connection would be that, at least in respect of Nargesh Mirza, would be dealing with the fundamental rights of women, not necessarily sexual harassment, but fundamental rights of women, which has a bearing on their right to work and this thing employment. But subject to correction, I don't think in any of those cases guidelines have been laid down with regard to anything specific. Guidelines, dehorse, or independent of what the statute already says. I don't think there is any such thing.
Right, sir. The next question has been asked by Jagjit Kumar Bhatt, and he asked that what is the difference between judicial review and judicial restraint?
Okay. Judicial restraint, according to me, is what limits judicial review. So, judicial review is that the court would review an action of the executive or the legislature and see and to check whether it falls within the constitutional sphere. Judicial restraint is that when you are so reviewing, you don't exceed the specific constitutional parameters. You don't exceed it and go beyond what the judiciary should actually be doing. So that is restraint. You restrain yourself from going beyond what you should actually be doing.
Perfectly answered, sir. The third question has been asked by SRV that in light of the Article 253, what is the legal stand of the Honorable Supreme Court of India on protection of human rights?
In light of Article 253, I wouldn't be able to
It is
answer this.
not related
Yeah,
to
I
the
mean,
topic.
unless you tell me which case law you're referring to,
Yeah.
I can be in a better position to.
The last question is by SCAORA EC. Will you be able to share the notes with us?
Yeah, I share those. I share the notes. They may not be very fair. I'll make it
No
as
worries.
fair as possible and I'll share it.
Thank you so much, sir. I'll just conclude the session by a vote of thanks.
Thank you. Thank you.
On behalf of the Supreme Court Advocate on Record Association Executive Committee, I extend a heartfelt gratitude to you, sir, for being an esteemed part of the SCAORA AOR Lecture Series 2025. Your illuminating insights on the judgments and related topics have been invaluable, and your expertise in highlighting the important paras and crucial topics for the exam will undoubtedly benefit the AOR aspirants. I'm sure a lot of aspirants who will watch this lecture will gain from your in-depth knowledge. And we appreciate your gracious presence, sir, and we look forward to having you on board again for the future SCAORA lecture series. Thank you, everyone who's watched this lecture in large numbers. I, on behalf of SCAORA, wish everyone the very best of luck for your exam. Thank
Thank
you,
you.
sir.
Thank you, Amit. Thanks, Nikhil. Thank you, Rinaji. Thank you, Meenakshi.